Mark Levine, XL Bradshaw Management Group. When you buy a condominium, oftentimes at the closing table, one thing that you'll be signing is a power of attorney. And the power of attorney is a document that is effectively going to give authority to the board of managers to act on your behalf in certain situations. This way, let's say there's 10 units in a condo, or maybe there's 1,000 units in a condo. You can't, as a board or as a managing agent, necessarily go after all of those people to sign on in the affirmative for a particular action. Maybe it's against a unit owner, maybe it's to purchase or foreclosed unit, or to start an eviction process on somebody that is not paying their common charges. But this is a document that is going to lay out the authority of the board of managers to act on your behalf in those situations. Now, where it's not going to change is when you have, let's say in your offering plan, anything that is over $25,000 needs to be approved by the unit owners in general. This is not going to give the broad authority to overstep the offering plan, but I do have a power of attorney here from a condominium, and it's effectively giving them a power of attorney for 3 different items, and it's basically if there's a foreclosure action or a sale in lieu of a foreclosure action, or a sale, all right, let's try that again. Mark Levine, XL Bradshaw Management Group. If you're buying a condominium, one of the closing table items that you're going to be signing should be a power of attorney. And the power of attorney is a tool that is used by a condo board so that they have the authority to act on your behalf in certain situations. And these certain situations are actually going to be noted in the power of attorney, so they don't have a broad use of it. And let's just say the offering plan calls for unit owner majority of approval for any expenditure that's over $10,000. They're not going to have the authority, unless it's specifically stated in the power of attorney, to go for that. I do have a power of attorney here that is 2 pages long, and effectively it lays out the course for information and the power of attorney powers that the board will hold and its successors will hold as long as you own that unit. And some of the things that are in there are basically if there's a foreclosure sale or if there's unit up for foreclosure, the board would have the right to buy that or lease that unit, based on its business judgment. Also, if there's an eviction notice or any penalties that go up to eviction, this gives the board the authority to go ahead and move forward with those cases without going to the general unit owners. And also, in this case, the 3rd paragraph is for any amendments that have to be submitted to the offering plan. This gives the board the authority to place those amendments with in this case, it's with a registered architect or an engineer, and as long as everything is truthful, they could file that amendment without going back to the unit owners and provide that. So one thing that's important is, we could have 10 units or we could have 1,000 units in a condominium, but if we're not able to get everybody in one place at one time and collect all of those, yes or no votes, it makes it a little onerous in these time-sensitive situations. So that is a factor to the power of attorney that's going to be sold at closing or signed at closing. And you should receive this at the closing table when you are purchasing a condo, and read through it, and it'll basically tell you everything that you need to know about what you're signing the board's authority on your behalf for. So that's a condominium tip for you. If you want to follow us on social media, you can find us at facebook.com/XLBradshaw. On Twitter and on Instagram, we are at XLBradshaw. I'm Mark Levine from XL Bradshaw Management Group. You could always email me for free advice, and I always get back to you at mblevine@ebmg.com. Hope that was something to put in your condominium toolbox. Till next time.